Okay, good evening, everybody. Evening, everyone. So nice to see so many people. There's a few seats over here. I feel like I'm telling the students, come to the front of the class. So welcome. So wonderful to be here on this occasion and to have our guest, Professor Ruth Mason. Welcome to the School of Law. This is the 27th David R. Tillinghast Lecture on International Taxation. The lecture commenced in 1998. It's almost as old as the International Tax Program itself, which commenced and had its first graduating class in 1996-97. I was part of the graduating class of 1998. Of course, the ITP itself was established and thrived in the context of the long-standing and unparalleled LLM program in tax here at NYU Law. So my name's Miranda Stewart, for those who I haven't met. And I'm really delighted to be here in my first year as a visiting professor of tax law and director of the International Tax Program, taking over from Professor David Rosenblum, who is here as well and well known to everyone, I'm sure. So I also hold a position as professor at the Melbourne University Law School in Australia. And as I said, I'm a graduate of the ITP myself in its second year under its first director, Paul McDaniel. And I was then also myself a visiting assistant professor here at the law school and got my start of my academic career in the ITP program. So Paul and colleagues established that Tillinghast lecture in the name of David Tillinghast, well known, I think, to some in the room, but David was a highly distinguished tax lawyer and tremendously generous person with his time and his expertise. He contributed across government, private practice, academia. You've got a bit more information in the program. And in many organizations that worked on international tax, including the International Fiscal Association, and also, he was chair of the scientific committee there, but also the American Law Institute program on US international tax some decades ago, which was highly influential on law reform at the time. Perhaps the American Law Institute should pick up the baton and start another project on US corporate and international tax. I think we have at least two other prior Tillinghast lecturers in the room, Dan Shaviro, our colleague here, and Mary Bennett, also here, so welcome. And I'd also like to say a little bit about this year's ITP. We have students in the room. We have 20 students from 16 countries, from all corners of the world, and we have some of our ITP and tax alums in the room, so it's great to see you. And finally, I'd like to acknowledge the Practice Council of the ITP, a wonderful group of people from all over the world that supports the program, and our chair, Irina Butt, as well. So let me turn to our speaker. Professor Ruth Mason is probably well known, certainly to the academics, the tax academics in the room. And she is the Edwin S. Cohen Distinguished Professor of Tax Law at the University of Virginia. She's also faculty director of the Virginia Center for Tax Law. You have a bio in the program, but it's a little abbreviated. We just couldn't get all the achievements into the program. But Ruth is essentially an internationally recognized scholar in the field of what you could think of as cross-border taxation. And that overlaps with federalism and interstate trade and commerce, sort of at the US level, but also in Europe and more broadly. And so she brings her deep knowledge of those two fields together in her study of cross-border taxation, subsidies, and state aid, which we're going to hear about today. I was trying to remember when I first came across your work, Ruth, or met you, but it's at least a decade, possibly longer than that. Certainly read a lot of Ruth's work. She published widely in the US in academic, but also in international tax journals, and is well-known, very well-known in Europe and internationally. She's made a reputation as a US scholar who knows a great deal about the European Union and how it works. And she's also a regular contributor to Tax Notes and sort of communicates in a broader context on tax. She's visited at many schools here in the US and also internationally, held a multi-year fellowship at the Max Planck Institute in Germany, and has also convened some really interesting international research connections, so like the Oxford-Virginia Dialogues with Professor Zilli Dagan. And she has a long relationship with NYU Law and with Professor David Rosenblum. Ruth was a visiting assistant professor and also a director here, a deputy director of the ITP for some years. And she left very good notes that, even though that was some time ago, very useful for me. And was one of the editors of the Festschrift for David recently, which is such a wonderful collection. So welcome, Ruth. We look forward to your lecture. Ruth will give the lecture. There will be time for Q&A. We do have a microphone. I'm not sure if it's necessary, but I'll let you know if people can't hear your questions, and then we will follow with a sort of drinks and nibbles reception after. Thanks, Ruth.
The things tall people can do. Yes. Yes. All right. Okay, so first, say cheese. Okay. Well, thank you, everyone, for coming tonight, and thank you, Miranda, for the generous invitation. I'm really delighted to be here to deliver the 27th annual Tillinghast Lecture, named for a giant in the field. Speaking of giants in the field, I have to spend a moment to acknowledge David Rosenblum. Some of you in the audience will recall that David and I started at NYU on almost the same day in 2002, which was almost the same starting day as Greg Zwollen. David began as director and professor in the International Tax Program, and I began as an administrator and not a professor in the Graduate Tax Program. My tenure at NYU was 4 years. David's was 25. David, I can see you starting to squirm already, but you can't leave. It would be rude. This is my Tillinghast lecture. My children are there, okay? Your legacy is evident in every aspect of the profession, in the students that you have mentored, the students whose lives you have transformed, the colleagues that you've become friends with, through your influential, you don't leave, your influential scholarship, which has illuminated complex legal issues with clarity and intellectual rigor. Generations of students have benefited from your guidance and expertise and your deep commitment to mentoring. For those who don't know, it was David who originally suggested that I might teach and who arranged for me to teach here at NYU. And that's why I ultimately left my job here at NYU to become, as an administrator, to become a professor at my own beloved home institution. David, as an administrator, as many alumni here can attest, you led the tax program with vigor and dedication, making it a world-leading program, the envy of the world. And today I met the new class, and they're smart and energized, ready to learn, and I'm so glad that you've placed the program in the competent hands of Miranda Stewart, who's probably the only person who could possibly have taken your place. So I look forward to seeing what the future brings for the NYU tax program. So now, on to business. I'll start with a question. When is a tax rule simply an ordinary part of a country's fiscal policy, and when is it illegal, an illegal subsidy that distorts competition and violates the law. The answer matters. For governments, the question has the potential to upend national tax policy. For companies, the consequences can affect whether they feel confident in their planning and investment decisions and whether they feel like they can trust the word of tax administrators. For citizens, the issue determines who shoulders the tax burden, which markets thrive, and how governments compete with each other. In the European Union, these questions come to life through the state aid rules in the Treaty on the Functioning of the European Union, the TFEU. These rules prevent member states from distorting competition by granting selective advantages, whether in cash or through the tax system. In 2016, the world saw just how powerful those rules could be. That's when the Commission first ordered Apple to pay about $14 billion plus interest on the grounds that Ireland had illegally subsidized Apple by allowing the company to pay too little tax. This past November, the Court of Justice of the European Union, the EU's highest court, overturned the lower EU court's decision, which had said that the Commission had failed to prove its case that Apple owed Ireland more tax. So the conclusion of that case was that Apple did owe Ireland that tax. Apple was a bombshell, but it was not an isolated case. It's part of a pattern of enforcement that's exposed deep flaws in how we identify subsidies in the tax context. Today, I want to walk you through those flaws, explain why the Commission's traditional method for identifying subsidies gets us into what I'll call the double bind, and then propose ways the Commission can go forward with new methods. For those of you who have been following my long-running series on state aid and tax notes, this is not going to be a provocative lecture about rotten cores or one that likens the EU arm's length standard to the Wicked Witch of the West. Sorry. Instead, this lecture will go beyond the Apple case to try to explain why the Commission went so wrong in Apple and the other recent cases, and what it could do to get the state aid concept on a more reliable footing. Okay. For the incoming class, right, you may already be lost. What's the $14 billion Apple case? What's state aid? What's tax notes? Well, that's how it is sometimes in tax. It all sounds like wah, 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 Charlie Brown's teacher. Every so often, you identify a word. Apple. I know Apple. They make my iPhone. Right? Well, they don't just make iPhones, right? They also make elaborate and clever tax plans. Eventually, you'll hear wah, wah less, and you'll understand more, and eventually you'll find yourself at a tax panel, and you will have understood everything, and that will be a great day, and NYU will help get you there, okay? So let's take a step back. What is state aid? It turns out that a major cause of confusion and unpredictability in this area is that the EU institutions have not clearly identified what state aid is, particularly when it comes to state aid delivered as tax savings, okay? The prohibition of state aid appears in Article 107 of the Treaty on the Functioning of the European Union. I'm going to read you that article. Aid granted by a member state or through state resources in any form whatsoever which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods shall, insofar as it affects trade between the member states, be incompatible with the internal market. If that sounds like I just described all taxes, that's how it sounds to me too, okay? So that's what the treaty says. The aid can be in any form. It can be a cash grant, a regulatory break, or a tax break. This prohibition has been around since the founding of the European coal and steel community, and it was originally intended as a backup measure to prevent states which had agreed to remove their tariffs and other explicit protectionist measures from implementing the same policies in another form through the use of subsidies. Today, the Commission, which is the EU institution that enforces the prohibition of state aid, recognizes 5 elements of an illegal state aid. There must be, 1, an advantage, 2, granted by a member state, 3, to an undertaking. The advantage has to be 4, granted selectively, and 5, it has to distort trade or competition in the internal market. Now, because distortion of competition as an element is presumed to be satisfied whenever the state confers a selective advantage, and because undertaking is a trivial requirement, it's just an economic operator, and granted by a member state is always satisfied in a tax case, the crux of the legal issue is selective advantage. This idea, selective advantage, is not self-defining. The Commission has said that a tax advantage is selective unless it applies without distinction to all firms and the production of all goods. That tells us a little, but not much. It tells us that a uniformly applicable low tax rate is not state aid, and the Commission has confirmed that. The Commission has also said that the very fact that a state has a rulings practice that confirms the application of domestic law to the particular taxpayer's facts is not state aid, even if only some taxpayers take advantage of the ruling process. To know how to interpret selective advantage, we need to know the norm or norms underlying the prohibition of state aid, but those have not been clearly articulated. I was recently sitting in a room full of tax state aid experts, and I put the question to the group about what the underlying normative value or values the prohibition of state aid was meant to protect. There were no volunteers to answer that question. That, in a nutshell, is the most serious problem facing tax state aid enforcement today. Not even experts can state with confidence what it's supposed to accomplish. This is a serious problem that has hampered states' ability to defend their tax policy choices. They don't know what they're defending against because they don't know what, exactly, the state aid prohibition is meant to prevent. Here's what we do know. The core of the prohibition is of subsidies that are protectionist. But the prohibition of state aid does more than that, I'm assured, by the experts. How much more? I don't know. One way it really departs from what Americans are familiar with under the Dormant Commerce Clause prohibition of tax discrimination is that in addition to preventing protectionism, it also prevents the inverse of that, the better treatment of interstate commerce than in-state commerce. So no favoritism for in-state commerce over interstate commerce, but also no favoritism for interstate commerce over in-state commerce. No tariffs, but also no import or export subsidies. Okay, so that's relatively clear. The prohibition of state aid promotes free trade within the union. But the problem is I'm not sure what the prohibition does beyond that, if anything. The Commission has told us that states can't favor specific companies or specific sectors or regions, but it's not clear to me whether those are derivative provisions, that is, subsets of the distortion between interstate and in-state commerce, or are they separate standalone prohibitions? Likewise, we don't know whether the prohibition of state aid limits tax competition only when that competition is protectionist or favors interstate commerce over in-state commerce. Or does Article 103 limit competition independently of whether that competition discriminates between domestic and interstate commerce? The court's confirmation that generally applicable low tax rates are not state aid suggests that the prohibition of state aid does not prohibit tax competition generally. But in pursuing cases, the commission officials often make statements decrying so-called loopholes that lead to low or no taxation, even when those loopholes are open to all. The failure to clearly define what the state aid prohibition pursues is concerning, especially when it generates deficiency notices of $14 billion. The court typically deems the distortion of competition element of state aid to be satisfied without any economic analysis. And this has enabled the court to avoid dealing squarely with the question of what exactly the prohibition of state aid prohibits. So the norm or norms beyond anti-protectionism have not been fully articulated. I won't say much more about the norms in my talk, though I would be glad to have this talk taken as a request for clarification. Is the goal of state aid enforcement only to promote free trade among the member states? Is it deregulation? Is it prevention of tax competition? Is it to ensure single taxation, as Commissioner Vestager often said in the pursuit of the Apple case? The commission staff once wrote in a working paper that a goal of state aid was to enforce a particular distribution of the tax burden between labor and capital. These are very different ideas from each other, and one would have thought at least the last was a matter up to the sovereign determination of the state, okay? Up to the state's voters. So the potential scope is very broad, and the language of Article 107 would support any of those interpretations, right? It wouldn't preclude any. So we have to await clear statements by the Commission and Court of Justice to know the full scope of the prohibition of state aid, but at a minimum we know that it protects free trade in the EU, and if we assume for purposes of this talk that that's the purpose, we can at least have a coherent discussion about state aid, okay? Promoting free trade is something of a balancing act because the member states retain power to design their own tax systems under the treaty. They set the rates, they define the base, they decide what kinds of activity to encourage and discourage. The TFEU does not create an EU-wide tax law, and indeed, EU tax laws require the unanimous agreement of the member states to pass. So the tax power is mainly retained at the state level. So this balance between the interest in the free flow of EU-wide commerce and national tax autonomy is the heart of the state aid problem in tax cases. Okay, so let's talk procedure. The way state aid cases work is that the burden is on the commission to prove that the state conferred a selective advantage. The commission opens an investigation against the member state. So in Apple, the commission pursued its case against Ireland. Ireland, in turn, would have to recover any aid from Apple from the company. That's how you have a case that's formally against Ireland that results in Apple having to pay $14 billion plus interest. The commission calls the amount paid over the recovery, which in Apple's case is a nice euphemism for a $14 billion deficiency initiated in 2016, finalized in 2024, relating to facts dating back to 1991. Okay, so the burden of proof is on the commission to show a selective advantage, and we said that at a minimum, a subsidy is selective when it's protectionist or when it favors in-state commerce over interstate commerce. So how then do we know when a state advantages a group, a taxpayer or a group of taxpayers, what's an advantage? Outside of tax, the commission often identifies advantages using what it calls the market economic operator test. This test analyzes a member state's investment in an enterprise and asks whether in similar circumstances a private party would have made the same investment on the same terms. Okay? This works well when what's being considered is a loan or an equity infusion by a state into a private entity. But there's no comparable when we're talking about tax. So in the tax area, instead of using the market economic operator test, the Commission has tried to describe illegal tax subsidies. And so in a 1998 notice, the Commission described as potential state aid a reduction in the tax base, such as a special or accelerated depreciation, exemption, deduction, or tax credit, or deferral. Okay? What does that remind you of? Tax expenditure. Right? The basic idea is the state forgoes tax otherwise due under its regular tax, and then that foregone revenue is an advantage conferred by the taxpayer and, if granted selectively, state aid. The 1998 notice made clear that the state aid concept also applies to actions taken by the tax administration, tax rulings. The way the Commission established state aid is a tax expenditure analysis. The method is that the Commission identifies what it describes as a reference system, which consists of the state's regularly applicable tax law, and then it checks to see if what the Commission calls, what the Commission calls a derogation, okay? A deviation from the reference base that benefits only a selective group in a way that can't be justified. The Commission and the Court of Justice never use the term tax expenditure analysis, but just from my description, it's clear that the Commission's method of identifying subsidies delivered through the tax system is identical to tax expenditure analysis. Okay, the first thing to observe here is that most of the time, tax expenditure analysis is a good way to identify subsidies delivered through the tax system. That's why we have a tax expenditure budget, and so many other countries as well. But any method of identifying subsidies that relies on tax expenditure analysis will also suffer from the well-known deficiencies of tax expenditure analysis, including the debate about the proper baseline. Okay. This was the crux of the dispute in Apple and essentially the other recent cases. Tax expenditure analysis cannot be used to analyze structural rules, including income allocation rules. So I would like to suggest that the primary problem in the recent and controversial state aid cases involving US multinationals arose not from a commission run amok or a court of justice that lost sight of the separation of powers, but rather the controversies arose due to a lack of fitness between the commission, the identification of the subsidy, the method used to identify the subsidy, and the type of subsidy that states conveyed in the recent cases. Okay. So one of the restrictions of tax expenditure analysis is that it forces us to divide tax rules into two types, right? The normal rules, which constitute the baseline, and then the special deviations, right? That's the spending that confers the benefit. So to take a famous example, your home mortgage interest deduction is spending through the tax system because the deduction is allowed even though the associated imputed rental income is exempt, okay? There's a deviation from the normal or regular rule. The regular rule is you don't get to deduct your expenses they don't go to earning taxable income. The deviation is the deduction for your home mortgage interest. So that's a tax expenditure, we say. But what about the deep architecture of the tax system? What about the structural rules? How do we know what's the baseline and what's the deviation? Choice of the tax base, income versus consumption, the taxable unit, married, single, pass-through, corporate, group, the rate structure, flat, progressive, timing rules, realization, mark-to-market, treatment of inflation, loss carryovers, and importantly for the recent cases, the income allocation rules. These are the rules for apportioning income across countries for tax. The structural tax rules, the scaffolding of the tax system as opposed to its individual prohibitions like the mortgage interest deduction, can represent major policy choices, and they can confer savings depending on the baseline you use. Does exempting the immediate return to savings provide a tax subsidy? Depends on your baseline. If your baseline's an income tax, yes. If your baseline's a consumption tax, no. If multiple baselines are possible, then for budget estimation, we can just pick one, describe which one we picked and why, and then we report the calculations based on that. Here, the consequences are more significant. They're calculating amounts due from taxpayers as a deviation from a chosen baseline. And it's the structural rules that have generated all the controversy in the recent cases. Okay, there's no agreed standard for what counts as a structural rule versus a normal provision. Reasonable people, reasonable member states will disagree. What is the baseline income allocation rule? Consider a branch. Is it a one-sided attribution? Is it two-sided? Is it apportionment? Is it something else? That will depend on your policy preferences. What do we do as a solution to this? Well, we could treat all structural rules as part of the baseline. That's essentially the strategy for domestic tax expenditure estimation. We assume certain structural rules are part of the baseline as part of the joint committee, what the joint committee under Ed Kleinberg's leadership described as a reference law baseline. Right? But if we're too broad and we include too much in the reference base for state aid analysis, then we risk immunizing types of rules from scrutiny. For instance, we can't say all tax rates or all allocation rules are a part of the baseline because that would provide a roadmap to states for constructing protectionist rate schedules and allocation rules. If instead of immunizing structural rules, we treat some structural rules as deviations, then well, now the Commission has to decide which ones are part of the baseline and which ones are deviations, and that invites inconsistency and accusations of overreach. What's more, the recovery amount depends on the chosen baseline. So if you put a structural rule into the baseline, the recovery is 0. If you take it out, the recovery could be massive, as an apple. So put differently, the choice about what to do with structural rules in domestic tax budget estimating is really about how do we want to convey the information? What do we want to convey? Okay. In the state aid context, there can be enormous money at stake, as Apple learned. Structural rules magnify every weakness of tax expenditure analysis, the ambiguity, the political judgments, the baseline fights leading to risks of both under and over enforcement. Massive, unpredictable amounts of recovery. By adopting the tax expenditure method of identifying subsidies, the Commission bumped up against the limits of a method that was never designed to calculate tax deficiencies. Okay, so that was all abstract. Let me give you some examples, okay? 1, Gibraltar. This was the first really controversial tax state aid case. Gibraltar is an offshore financial center. It had an old, ring-fenced corporate tax regime that constituted clear state aid under the old tax, the traditional tax expenditure analysis. So Gibraltar planned to amend it, but Gibraltar really wanted to keep the virtue of the system, which was that it was ring-fenced and only benefited certain holding and financial companies. But it couldn't do this while singling them out by name, because that would be state aid under the old approach. So the clever policymakers of Gibraltar decided to propose a corporate tax system that was based on payroll and property in Gibraltar, where the total amount of tax a company would be liable for was limited to 15% of its income. Okay. Why this regime? Because the holding and finance companies that Gibraltar sought to favor wouldn't have much payroll or property in Gibraltar. They had a light footprint there, whereas ordinary Gibraltar operating companies would have payroll and property, so they wouldn't have liability. So they recreated the virtues of their prior regime with this new one, even though there was no express derogation in the law in favor of holding and financial companies. The commission saw the intention, but under the traditional method, there was no obvious derogation from the domestic system. The same system applied to everyone, but its impact was different. To respond, the commission improvised. It measured Gibraltar's regime against an external benchmark. The benchmark the commission used, and now I quote, is a general system of taxation for all companies. Okay. The commission wasn't really clear on what a general system of taxation for all companies was, but the commission was clear that such a system should have generated more tax than the Gibraltar system did. The move of inventing a domestic reference base was controversial because it was seen as stepping into the tax policy arena reserved to the member states. Okay. Second example, my favorite example, Apple. Okay. The Apple case brought the baseline problem into sharp relief. The Apple tax plan was complex. It relied on mismatches between US and Irish law, principally in how they defined corporate tax residence. The United States defines corporate residence by place of incorporation. Ireland defined it by management and control. As a result, Apple was able to incorporate companies in Ireland, manage and control them in the United States, and they would be stateless for tax purposes, taxed on their worldwide income by no one. Apple loaded these stateless subsidiaries up with profits in the hopes that they wouldn't be taxed presently anywhere. Each of these stateless companies, there were two that were important, had a small branch in Ireland. Okay? Ireland taxed the real activity of the branches, but the commission argued that Ireland ought to have taxed all the income of the stateless companies that were incorporated in Ireland but not tax resident there. Okay. Irish law did not provide for the worldwide income taxation of non-resident companies, which state's law does. Instead, Irish law would only tax the income associated with the actual functions and assets attributable to the branches. The branches had some substance. It just wasn't possible under Ireland's one-sided branch profit allocation rule to draw all the profit of the stateless companies into Ireland. But the commission looked at the overall global result, which was the payment by Apple of an effective tax rate that was low. The commission reasoned that the outcome was wrong and there had to be a way to put it right. Okay. Now, in my view, if there was tax avoidance by Apple here, it was principally US tax avoidance, not Irish tax avoidance. And that was a problem for the commission because Ireland could accurately be claimed to be following its own rule and taxing the right amount from an Irish perspective. So the commission couldn't find a way to tag Apple with receiving a subsidy under Irish law. It needed another tactic. So it pulled a page from the book it wrote in Gibraltar, and it propounded an external reference base. In the case, instead of talking about a normative reference base, talking about a vague general system of taxation for companies, the Commission propounded an explicitly normative income allocation rule. At first, the Commission argued that irrespective of Irish law, as a matter of EU law, Ireland was required to tax Apple on an arm's length basis. To flesh out the EU's definition of arm's length, the Commission used the OECD guidance that had not yet been adopted by Ireland, and indeed that had not yet come into existence. So the Commission retroactively applied a future standard to the Irish administration. Specifically, the Commission applied the authorized OECD approach, AOA, to allocate income to the branch, but then the Commission also modified that standard so that it applied an allocation rule of its own invention. I heard a gasp. Yes, gasp. That's what we all said collectively, okay? The Commission's reasoning was complex, and its theory of the case changed repeatedly over the decade-long litigation. I don't want to get into the details here. I've written about the case ad nauseum. You can look to my work in tax notes. The point here is that the Commission used a reference base that was external, right, to Irish law. The reason it had to do this was that Irish law focused only on the income of the branch. The reason Irish law was narrow in that way was probably motivated, at least in part, by a desire to facilitate income shifting from the United States and other countries by Apple and other US multinationals. I want to be clear that I'm speculating about Ireland's motives here, but what I'm trying to convey is maybe there was a legitimate reason for the Commission to be interested in this case, a reason that goes beyond what the Treasury Secretary accused the Commission of, which was just rank discrimination against US companies, right? But did the Commission use the right approach? Ireland may have designed its law to be convenient for US companies, but the problem with the Commission's approach in Apple was that it was ungrounded and illegitimate. The Commission has no authority to invent the tax law of Ireland, even if it relies on the AOA to do so. The AOA is just an international standard. It's not law. It doesn't apply to any country that doesn't adopt it, and it certainly shouldn't apply retroactively. The takeaway here is that the failure of the tax expenditure analysis as a technique, it's unable to say why or whether Ireland's relatively narrow branch profit allocation rule was state aid because there's no obvious domestic baseline against which to characterize that branch rule as a deviation. That's the problem, right? The baseline caused the Commission to look around for new methods. That's how it landed on this external benchmark. It wasn't necessarily that the Commission was power mad or that it was jealous of the BEPS project and wanted to flex its muscles or any of the other things that the Commission was accused of. It might have been those things. It wasn't necessarily those things, okay? The problem was that its usual tool, tax expenditure analysis, just wasn't fit for the task. But external benchmarking raises legitimacy questions. Where does the Commission get the authority to impose such a norm? If the Commission gets to impose an external benchmark in every tax state aid case, then the Commission essentially has the power to determine member state tax laws. Okay. Third example, McDonald's. Okay, here, Luxembourg interpreted its tax treaty with the United States to preclude Luxembourg from taxing. Specifically, Luxembourg reasoned that McDonald's subsidiary in Luxembourg, which had a presence in the United States, okay, so you have McDonald's US company, Lux subsidiary, and then a PE of the Luxembourg subsidiary in the United States. In Luxembourg's view, the US ought to have regarded that presence as a PE and taxed it. Okay? But, in fact, the US did not regard it as a PE and did not tax it. Luxembourg took the position that it would exempt because, in its view, the branch was a PE and should have been taxed by the United States. Okay? So students might have just heard wah, 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 wah. Maybe more of you heard that. It doesn't matter. The bottom line is that there was a non-tax result, a double non-tax result. Luxembourg could have prevented it by imposing tax as the resident state, but didn't. Okay? Okay. So is there an illegal subsidy here or not? Must a state take an opportunity to avoid a double non-tax result by interpreting its treaties to prevent the double non-tax result? What do you think? Is that a subsidy? You guys didn't think you were on panel tonight. Okay, so the commission says, at first, yes. Best practices for treaty interpretation would avoid the double non-tax result, and so EU law requires Luxembourg to avoid the double non-tax result. Okay? But on second thought, the Commission decides, no, there's no state aid here. Luxembourg was just applying its usual interpretation of its own law. Okay? And its interpretation just happened to be different from that of the United States, and this difference produced a tax gap. No harm, no foul. Okay. This is a case where the state's interpretation of its own law was incorporated by the Commission into the reference base, rendering that interpretation incapable of conferring state aid. Last example, the Hungarian turnover taxes. Hungary's turnover tax had steeply progressive rates. Low turnover companies were exempt. The highest turnover companies paid tax at a rate that was 60 times higher than the rates applicable to the companies in the lowest non-zero bracket. Why did the Commission accuse Hungary of state aid? Well, almost all the companies in the exempt brackets were Hungarian, and all the companies in the highest bracket were foreign. So, is this a hidden protectionist subsidy to Hungarian companies? What do you think? How can you tell? The Commission thought it was a hidden subsidy, protectionist subsidy, for the domestic companies. But how could it quantify the subsidy? Again, the problem is there is no clear reference system. The Hungarian turnover tax was progressive across several bands. Which rate is the reference rate? The Commission used a tax expenditure approach, but that forced it to invent a reference base with a rate. So the Commission said that there was state aid and that the amount of the state aid was measured by a rate that Hungary applied after the case was over when it amended its law. And the Commission said Hungary could either apply that rate to everyone going back, or it could pick another rate and apply it to everyone. That's an obviously unsatisfying, kind of indefensible litigation strategy. But the Commission came to this uncomfortable argument because it was stuck in a tax expenditure frame that forced it to identify a baseline when one wasn't readily available. It had to make one up. Okay, so these cases expose the double bind of tax expenditure analysis. Structural provisions, the deep architecture of the tax system, like the allocation rules, taxable unit, the rate structure, can create advantages. But deciding whether they're normal or special cries out for external benchmarking, which is inherently political and therefore outside the institutional competence of the Commission and EU courts. where the states retain significant tax sovereignty. If you stick to the domestic reference law, you risk under-enforcing the prohibition of state aid, missing cleverly designed regimes like Gibraltar's perhaps, like Hungary's perhaps, that have what are perhaps protectionist effects, even though they do so without using overt deviations. But if you jump to external or invented benchmarks, you introduce more problems. It's unpredictable. No one knows when the Commission will decide to swap an external benchmark for the domestic law. Nobody knows what the benchmark will be. Okay? It's not the Commission's role to tell the states what their tax law is. Finally, under an external benchmark, the repayment amount is measured against an asserted benchmark that was never the law of the state. When budget estimators measure tax expenditures against otherwise applicable domestic law, they generate an estimate of foregone revenue that's appropriate to the tax policy choices otherwise made by the state. When the Commission does it, it has nothing to do with the law of the state, but it imposes a monetary penalty on the taxpayer. So in short, external benchmarking risks turning state aid into a vector for arbitrary tax assessments, bypassing domestic procedural rules meant to preserve the rights of taxpayers, and bypassing the domestic political process designed to preserve voter choices in tax policy. So what do? We need methods that can work in the well-known situations where tax expenditure analysis doesn't. To be clear, I'm not advocating abandoning tax expenditure analysis. It works well much of the time in state aid. There are lots of cases, uncontroversial cases, in which the Commission has used tax expenditure analysis in a quotidian, appropriate fashion to identify state aid. Faster amortization for foreign than domestic assets, that's a real case. Right? Tax expenditures handles that case beautifully. Exemptions for stopover taxes for domestic vessel owners but not foreign vessel owners, that's another real case. Tax expenditures got that one. Okay? But we know, and we have known for decades, where tax expenditure analysis is vulnerable, and we should stop trying to use it in those cases. Moreover, the Commission knows that too. That's why it reached for these other methods in the recent cases that got it into trouble. Methods like inventing an EU arm's length standard or saying that the reference base includes implicit tax rates that never actually apply. It should hardly surprise us that those methods were controversial and ultimately rejected by the Court of Justice. Okay. But, and this is a separate criticism, in rejecting those claims, the Court of Justice often did even more mischief. Okay. The EU courts have not fared particularly better than the Commission, at least in part due to the perception of a need to adhere to tax expenditure analysis. So think back to Gibraltar. That's the case with the payroll and property tax. The lower EU court vacated the Commission's decision saying, well, you have to use a reference-based approach in every case. Okay? The Court of Justice reversed, agreeing with the Commission that because the Gibraltar regime wouldn't generate tax for all companies, it was illegal state aid. So the court essentially ratified the Commission's invented external reference base. Neither the Commission nor the Court of Justice fleshed out what that corporate tax system looks like, but what they seemed to have in mind was something like a more typical corporate tax. The Court of Justice ended up having to narrow Gibraltar, essentially limiting it to its facts in 2016 in a case called World Duty Free. But in the in Fiat, more recently than that, 2021, it revived Gibraltar. So now we don't know the status of that case. In the Apple case, this likewise did not generate a clear precedent for the future. The lower court held that Irish law was similar enough to the OECD AOA, right, that by applying that the commission was permitted to apply the external reference base. This reasoning was vitiated not long after in a different case called Fiat, in which the Court of Justice sitting in Grand Chamber stated that it violated the treaty for an EU institution like the General Court to substitute an external reference base for the state's own law. You can't apply an external reference base. You have to apply the state's own law. That's what Fiat says. Okay, of course, as is well known, that holding didn't help Apple because the Court of Justice decided that Apple was procedurally barred from benefiting from the holding in Fiat. For criticism of that holding, you can look to my article in Virginia Tax Review with Stephen Daly. Okay, so the recovery order made by the commission in Apple, which the commission calculated using an external reference base, ends up standing in Apple, even though the court in Fiat says that the use of an external reference base is an infringement of EU law. By assuming that the Fiat decision holds up, and the commission can't use external reference benchmarking in future cases, what ought to happen in a case like Apple? Do we just assume that whatever allocation rules the state uses are fine? The EU courts never had a chance to consider the McDonald's case because the commission, on second thought, right, decided there was no aid. And in the Hungarian turnover cases, where the commission had argued that Hungary could decide what rate it would like to apply as part of the recovery, the Court of Justice held that there was no state aid. The court didn't simply hold that the commission failed its burden of proof. Instead, the court went further. It said, essentially, that a state's progressive tax rates had to be considered part of the reference base because they reflect ability to pay. The court did not consider any evidence as to whether the brackets in the Hungarian tax reflected ability to pay or intended to reflect ability to pay, or whether they were adopted for more nefarious reasons. The Court of Justice essentially directed the commission to ignore graduated rates as a potential vector for state aid. But the court couldn't possibly have actually meant that, since even if this wasn't true of Hungary in the case, it's obvious that a state could engage in protectionism by using rate differentials or threshold choices. Think about the French DST, digital services tax. The Hungarian case appears to be a roadmap for state protectionism. All the state has to do is pick a non-obvious proxy for nationality, like turnover, right? Assess a higher rate, and give ability to pay as the explanation. So to sum up, what's been going wrong with the recent cases? It's not necessarily that the Commission and EU courts have run amok. It's that the cases have involved challenges to structural rules, things like allocation and rates, and the traditional tax expenditure method doesn't work in those cases. Okay? So what do the Commission and courts need to do? First, they should acknowledge that they use a tax expenditure approach to identify tax subsidies. They should acknowledge that this approach has limits and can't be used in every case. As applied to structural rules, it's unpredictable, illegitimate, and excessively constrains member state autonomy. They should issue written guidance explaining when tax expenditure analysis is suitable and when it isn't. And when it isn't, what methods will be used instead. This means that the Commission needs to develop new methods to identify advantages in these other cases. I've argued in a law review article that they can use the internal consistency test. And my students are like, yes, you're obsessed, we know. My former students. They can use the internal consistency test invented by the US Supreme Court under the Dormant Commerce Clause to handle allocation cases. That's what the Supreme Court invented it for. It works as an economic matter. They can use that test. Steve Daly and I argue in forthcoming work that they may have to engage in impact analysis for other cases, like the rate cases. Daly has argued that they should use administrative law to decide cases involving administrative pronouncements and rulings. Okay. These challenges are difficult, but they're important to achieving the norms underlying the prohibition of state aid, which at a minimum are that states should not use their tax systems to discriminate between domestic and interstate commerce. Thank you. Happy to take your questions. Yeah, so.
Do you want to just repeat the question,
Okay,
just so we have it
so
on
the question
the
is,
mic?
what if there had been no ruling
Yeah.
and Apple had just reported its profits consistently with Irish law? There would have been no evidence that the Commission would have received. So what happened was the Commission asked all of the member states to hand over their rulings and then started looking at them. But it was specifically looking at Apple after an investigation by the US Senate, and where an Apple executive tested, we have a low tax ruling with Ireland, and the Commission said, you have a what now? And so if there hadn't been a ruling, well, first, that executive wouldn't have testified that, right? And then there would have been no memorialization of this decision. And you know, the Commission wouldn't have been able to say that some of the things that it did in its investigation, which was that there wasn't very much checking or verification by the Commission that the position Apple was bringing to it was consistent with the facts. If it had just taken the position, right? And maybe there were other taxpayers in that situation. I mean, this kind of came as a surprise, these state aid investigations to US practitioners. And at the time I used to go around and ask practitioners, well, what do you tell your clients? Like, how do you avoid this? And the answer I got was, oh, we just tell our clients, don't get rulings from small countries. Which actually sounds like pretty good advice, right? So it's not you don't do it, right? Maybe. The aid perhaps wasn't in granting the ruling, right? So if the aid was in having an allocation rule that was too generous, then the question is, too generous by what measure? And that's the thing you need the baseline for. So the accusation isn't necessarily that that the Irish tax administration did something nefarious, right? It's that the way Ireland calculates the income of a branch is itself problematic. But
Right.
then, by what standard? So, I mean, let's be a little broader than chips, right? I think we can say even though I just gave a whole lecture about how they're not clear about the norms, right? It's broader than chips, right? So let's say it's anti-protectionism, but also anti the inverse of protectionism, right? Favoring interstate over in-state. They can implement that, right? They don't need to use a tax expenditure approach in every case. They can use internal consistency. They can use impact approach. They can see how the tax actually affects the market and whether it's protectionist. If they put in a little more effort, right, instead of assuming the conclusion of every case, the market is distorted in the way we say so, we'll assume that part. That's the hard part. They have to do that part. I think that there is a coherent way forward, and I do think that, my recommendation here isn't the commission should get out of the business of trying to enforce tax state aid because it's impossible or because they're bad at it. I mean, states will try to implement protectionist subsidies, and it makes sense in a common market that has these freedoms, right, where all of the assets are free, all the productive factors are free to move, that they should curb that. And they have already agreed to it, right? They don't have to further agree. The commission just has to have a coherent set of regulations, ideally written ones, right, that identify what falls afoul and what's fair game. Well, so the U.S. company sits at the top, then you have the stateless company in the middle, and below that you have operating companies in your EU member states that are paying, tax-deductible licensing fees up to the stateless company. So in that sense, right, so who's injured by the stateless income planning? All the countries of Europe, right, that are having their bases eroded, the US, because the IP leaves the US and with it the tax base. Whether countries, one might say, well, countries have unilateral measures that they can, apply to respond to that competition. But I think that's kind of the crux of the complaint about Ireland.
Perhaps the point of the EU is to avoid unilateral measures as well?
Exactly.
Is that? Did I see one more over there? I think we might wrap up and let Ruth have a drink and have a chat with all of you. So wonderful to see you here. Before she does a final word.
If you're one of my former students, I'd like to take a picture of you. Could you come up? Or maybe over there? What's a good background? Maybe go over there.
All right.
Okay, thank you.
Thank you, Ruth.